Good afternoon, everyone. Thank you for attending our webinar discussing the impact of social media on the rules of engagement between public officials and their constituents. A few things to get us started. All of your telephone lines have been muted. Any questions you have during the seminar must be submitted using the Q&A button on the top of your screen. Deborah and Meg will do their best to answer all questions at the conclusion of the webinar, and if not, we'll get back to you via email or their contact information will be available on the last slide. We are offering CLE credit for this webinar. All CLE certificates and a copy of the PowerPoint slide deck will be emailed out to all attendees next week. And now for our webinar. Government entities and elected officials are becoming more accessible and connected to the public through social media. The 21st century question is what may they do and not do to regulate the public's participation on social media accounts? Deborah and Meg will explain how courts are analyzing different social media scenarios and the key factors that public entities and officials must consider when developing policies that govern the use of their social media accounts. They will provide important updates from oral argument on March 26th in the closely watched case of Knight First Amendment Institute versus Trump. In that case, the U.S. Department of Justice is appealing a lower court's ruling that President Donald Trump's blocking of critics from his Twitter account is unconstitutional. And with that, I'll pass it over to Deborah and Meg. Thank you for being with us.
Thank you so much, Stephanie. I think before we start, I want to give a shout out to Stephanie and her team for urging us to take on this topical area. And man, timing is everything, as they say. So we have in the last 60 days a decision from the Fourth Circuit along with the Fifth Circuit and then oral argument in the Trump case. So we've got a lot to talk about. What we thought we'd do here today is I'll be the leadoff hitter. I want to give you a little bit of the constitutional framework and then I'll apply that in the analysis that happened in the Trump case. Everybody is watching that case, and so it's got a lot of marquee play, and we will give it its due presence in our discussion here today. I do want to also say, though, and set expectations here, is that I know that everybody wants to leave these having all their questions answered. But I think we have to bear in mind that right now this is an evolving area of the law. So I think the expectation here should be that we give you a good framework so that you can analyze these issues that may come up. And then as well, so you can see the other circuits across the country, how they have started to answer these very quirky First Amendment questions. A bit of a disclaimer or a caution or a viewpoint imprinter on myself. We have tried very hard, Meg and I both, to make sure that this analysis is all viewpoint neutral. And it's even-handedly applied in our evaluation of the cases across the country. But I do want to have you all keep us honest. If you see something that you think that we're not quite living up to that, send us a little comment and we can have some discussion on that. We've tried to analyze these arguments as we see them to be intellectually honest or not, and that whether or not they're properly grounded in First Amendment jurisprudence and not grounded in simply our political views or the political views of the different parties involved in these new litigation here. So I hope that you find that this helps you make your way through these very nuanced issues. And as well, we'll set some time at the end. As Stephanie mentioned, if we don't get to your question, feel free to reach out to us afterwards should time get away from us. But let's jump into the framework and how this all unfolded. As most of you know, social media is now being used by officials and city employees extensively. It is originally started as an old school of notifying people about public disasters. And of course, that's still a way it's very effectively used, as we've seen with all the wildfires and other disasters we've had here in California. But it really has transformed, and now it is becoming the public engagement platform I do think it's a little appropriate, that we are here at a webinar. We really appreciate that the personal and professional lives of all of us have been transformed by electronics and these different platforms. In talking about this, whether we're talking about emails, texting, social media platforms, the big challenge is how are the courts addressing this new communication technology that is now in practice by all of our local electeds along with employees. So now we get to the issues of where old case law meets new technologies. I'm sure you all have found in a number of areas that the law always is behind, whether we're talking about issues of texting and trying to talk about discovery, whether we're talking about the Code of Civil Procedure or the Evidence Code, it always lags behind. And so now we are seeing the efforts by the case law to try to catch up. So the First Amendment is being applied to these different platforms, whether they're Twitter, Facebook, Instagram, Snapchat, or whatever that new emerging technology is. I'm not sure if any public entities are now using Slack, and I'm always wondering what the next platform is. Usually I think of, we check with our kids of wherever they're moving to try to get away from us. But all of those platforms that start being personal, then several months become used in a professional setting. So we need to be on the lookout for those. So the big question here is, how should these platforms be classified? Is it a government-sponsored or a private platform? And I just want to sit with that for a minute, because that really is one of the key questions, and you'll see it when we get into these cases, and you'll see it in the discussion of the Trump case. And how do we decide that? We've got some questions that came in already, and one of the questions was if it is someone's personal Facebook page. And so that carries with it, if you say it's personal, that then it's private. But is it private? And can you be confident in that classification? I want to think about this a little bit as it relates to Trump, and I'll talk about that, but in Trump, the DOJ argued that the Facebook page was just like the Mar-a-Lago resort, that it was a private platform. And that's interesting and curious. I'm not sure if that's going to hold true, because it is the Mar-a-Lago could become indeed and open to the public. And so then it transforms to a designated, perhaps, public forum. I realize I'm getting ahead of myself a little bit, so I better go back to the basics. And let's talk about those a little bit. Is it a traditional public forum? Those, as you may recall from all the constitutional case law that we studied in law school, are things like parks, public streets, town squares. Obviously, it isn't traditional in that sense of the property interest, but is it traditional in the way the discourse is happening? In other words, is it the modern public square of the digital age? I think, again, it's another quirky, nuanced issue. Or is it different? And is it more akin to a bulletin board where you only post designated topics? These are the interesting questions we're going to be grappling with. So first, we wanted to play what's now, Megan, my favorite game, Family Feud Constitutional Edition. So on the left-hand side of the board, you see here some of those traditional public forums: City Hall, library, park, And then one that's kind of a little more newfangled, airport. Roadway, of course, on the right-hand side is more traditional. And then we have Twitter, Facebook, etc. So let's see if we can make our way so we can score big in Family Feud. Traditional public forums, you all remember, where people are on their platforms expressing their views in the public street, in the town square, outside the curtilage of City Hall, as opposed to non-public forums. That would be a military base, an airport, is sort of in the hybrid, but a courthouse lobby and post office are seen as non-public forums. It becomes very difficult to place the social media platforms within those two constructs. So it really gets down to a factual, very nuanced analysis of how they might most fit into those two categories. As you all know, there's no Ninth Circuit decision, no Supreme Court decision that addresses social media in this context. There are some cases about regulation of content on particular social media accounts, but not in this construct of analyzing and deciding on this forum classification. And the reason I'm spending so much time on this is because it's really key and the linchpin of the legal framework that unfolds. That is the key question in Trump. I would offer to you, as you're making your way through this, to tease through and really jump into the issue of, is there any First Amendment issue involved? Not take it for granted and say, well, let's just say it's a public forum. One example might be, I think of the last medium that was discussed in the case law was donation boxes. There, the Ninth Circuit, ultimately in the decision out of Oakland, found that donation boxes did have certain First Amendment rights, but also the court noted that it hadn't really been disputed by the parties. So there's an open forum, so to speak, to debate these issues. Just reminding everybody what the test is once you decide if you have a public forum, that you need to have a content-neutral policies. They need to be reasonable time, place, and manner, narrowly tailored, and they have to leave open, ample alternative channels of communication. These are very easy to articulate, but they're very difficult to apply on the ground in your communities. I put on the right-hand side of the screen the content-based analysis, where you have strict scrutiny, and it's presumptively invalid. Obviously, you don't want to get to the right-hand side of the board. It's a death knell, and so we should try to avoid getting to the right-hand side of the board. One of the things that I wanted to think about in implementing how you decide where you are in content-neutral or content-based is one issue that comes up a lot is I see folks saying, well, we'd like to limit all the discussion to local community interest. And Meg, I'm wondering what you think about that as a content-based or a content-neutral designation of a topic.
Well, I think that that particular limitation would be viewpoint neutral, so could be something that, and I know in the coming slides you'll talk about this, that may be okay in a limited public forum. My sense of it is, though, that courts would most likely see that as being a content-based distinction, in particular after the decision by the Supreme Court in the Reed case, where they the majority opinion there went with a very kind of strict understanding of what content-based means. And so my sense, again, is that would be considered a topical content-based distinction. What is your sense, especially in the kind of post-Reed world?
I think that those are really good points and I share the same view. And I also want to just call out, we're talking about the Supreme Court decision in Reed versus Town of Gilbert regarding signage, and note that I do think that the cases will draw upon the established case law in other mediums to analyze this. So thanks for reminding us all about that. The non-public forum test is called out here on the next slide. These restrictions need only be reasonable and viewpoint neutral. Of course, what's reasonable to one party may be very restrictive and unreasonable to another, so that always becomes a challenge.
Yeah, and I'll just jump in there too, Deborah, that sometimes it can be difficult to tell whether something is content-based or viewpoint-based. Sometimes it's very easy to tell this is a viewpoint-based restriction, not a content-based one, or vice versa. But it can become very blurred as well as you get close to the line on those issues.
Well, I tried to move back in the slides, and I messed that up a little bit. So let me get back to where we need to be. And this is slide 10 about a designated public forum. And this is, I think, again, another point I want to earmark for us all. Designated public forum is one that the government has intentionally opened up. When that happens, and if you fall into this category, then the court reviews, and the focus here is whether or not it follows the same rules as a public forum. So there's the review and the analysis that is examined there is the same. So some examples that we already have of designated public forums would be the interior of the City Hall when you allow certain artwork to be up, municipal auditoriums that are letting certain plays or other expressive activity that's occurring, school board meetings. I think as well it was a designated public forum, that Little League softball field, when they let all of the fences be used for different signage. So I think the focus here for social media is going to be whether or not you're a designated public forum, or the next category shown on slide 11, what's called a limited public forum, and you've opened it up to certain specific topics. Again, the standard that is applied here is the same review as a non-public forum. So you can see if you succeed and the court agrees with you that you're a designated public forum, you have the more stringent review as opposed to if the court says, nope, you are a limited public forum. So in that regard, it always begs the question, well, how do you make sure you're one or the other? Or what's the tipping point? And I don't know, Meg, if you have any ideas about what the tipping point is between those two designations.
Well, I think this is a particularly interesting question and will be interesting in this context of social media used by government officials as well. The courts haven't ruled specifically across the board in this area yet, but certainly I think that's going to be a critical question, because I don't think that these social media platforms are going to be seen as traditional public forums. Normally, it's ones that are seen as being held in time immemorials, places for public expression, and they're simply new platforms, so they probably won't be deemed traditional public forums. So then the big issue is going to be, are they designated or are they limited public forum? With limited public forum being a lot of times where the public agency wants to end up because of the less stringent requirements and the more ability to regulate. So a key with that is setting out what the particular limits are for the forum, and then even-handedly enforcing those. So to get back to your question of kind of what's the tipping point, I think it's going to be whether there is an articulated policy that is reasonable and viewpoint neutral and is even-handedly applied. So that is a lot easier to say than to actually do. There are cases where the public entity has claimed that something is a limited public forum, and the courts have said, no, you didn't even-handedly enforce any type of viewpoint neutral regs.
So thank you for that, Meg. I think there's 2 points that are key there. We need even-handed enforcement, and we need clear and concise written policies. The clearer and the clearer the policies, the even-handed enforcement, the more likely you are to be able to win the designation of a limited public forum. I also think we should think about the issues of training on those policies. I think that's going to be a 3rd point. I want to, because I need to get to the Trump case, so I'm going to take through some examples of social media of where we think its designation is. Example number 1 here of applying these public forums to social media, that we have a platform, a Facebook page that is solely for government speech. You can't have any interactive comments. That one, the First Amendment doesn't apply. Ding, 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 you win, and you have the lesser standard of analysis there. Then we have example number 2, where we have some limits on public discourse. This one is the challenge that we were just talking about. We need viewpoint neutral restrictions and even-handed enforcement. So it's going to be a historical record of your jurisdiction's application of its policies even-handedly that will come into play and drive whether or not you succeed there. And then the last example is social media with no limitations and no policy in place. That's wide open. That's going to be likely viewed as a public forum. This reminds me of Elon Musk, where he says Twitter's a battlefield. It should be wide open. There's harsh comments. Everybody should have thick skin out there in the Twitter land. So let's talk about that marquee case, the Knight Institute versus Donald Trump. Donald Trump blocked several users from his Twitter account, The Real Donald Trump, and those folks sued in district court. It's interesting to note that Donald Trump has 33 to 50 million followers on The Real Donald Trump. In contrast, his POTUS account has 19 million followers, and his White House Twitter account has 14 million followers. I don't think there's any debate that he's using this account to talk about a variety of public issues. He's been talking about everything from the Mueller report to the North Korea to cabinet appointments. The account was created before he came into office in 2009. He's going to keep the account after he leaves office. We know that Sean Spicer and others have the ability to block folks. And we also know that these folks who were blocked had been blocked based on criticism that they made of President Trump. One of the issues that came into play as well was the fact that there is an ability to work around the blocking that President Trump put in play at this account. So the district court judge, Buchwald, out in Manhattan, found that the president's account was a designated public forum and his blocking was viewpoint discrimination. The DOJ there had argued that the Twitter account was not public property, and the blocked users were not then entitled to any relief under the First Amendment. The matter went up to the Second Circuit, and argument was just held this past March 26th. The great thing about all these platforms is you can go online and listen to the argument, and it is very, very interesting. The court's grappling with the two main questions. Is the Twitter account a public forum, and is the blocking by President Trump official action? Now, the DOJ took an approach where they wanted to start with question number 2, and they basically said, listen, that blocking of those particular individuals was not official action. He didn't do that in his role as president. He did it on his own personal account. He's a private actor. The opening questions then are, well, if he's a private actor, why is the DOJ here? I never heard an answer to that question, and I think some of those things really have worked against the DOJ in peeling back their arguments to see if they're intellectually sound, because they argue in a different Twitter account that it is official action and that they are official statements, but they don't really make the distinction of how the nature of the digital platform is different. So they claim it's not a forum, it was a personal account. So on that regard, I'm really curious about whether or not the court might find this to be a personal property and a personal account of President Trump or of your, local mayor, of Mayor Garcetti. So I analogize to the issues where we had pennants and signs going up in the public right-of-way, and we would say, hey, the city can't outsource those to avoid the First Amendment constraints. Well, here, the president isn't outsourcing that. It's a platform that was already created, and he's just taking advantage of it. So I originally was not very much buying into this argument, but I can see that maybe it has some distinctions that might be worth a run of a valid argument here. The other issue that came up that I wanted to highlight for us all was the DOJ argued there's really no harm, no foul here, because in the Twitter accounts, these folks can do a workaround and they can still stay and be part of the larger conversation. I'm not sure that's good enough in the First Amendment analysis. As I recall, if you block someone, just the fact that they could go down the street or that they could get in through the back door of another fake Twitter account would not solve the problem of the potential First Amendment violation. But again, very curious issues. We all need to become more familiar with Twitter and all these social media platforms. I know I've spent more time on Twitter than I really wanted to try to make sure I understood how it was operating. In contrast, the Knight Institute said, hey, this is a digital town hall. We only have this body of law that seems to be applicable here, and applying it, we clearly find, the court clearly should find that there's been a First Amendment violation. These folks were talking about disagreements, fundamental disagreements with the administration's policy on immigration and health care. This wasn't anybody talking about whether or not we liked your pictures of your children, or grandchildren bowling or their Easter egg hunt. This was all about official administrative policies. And it wasn't just a one-way interaction. It was intended to be an engagement, and it was intended to get interaction. I do raise the question, though, and wonder what would have happened if the president had actually blocked some anti-Semitic comments or some folks who were in support of the folks at Charlottesville. Would that have, colored things factually a little differently here. A takeaway from the judge's questions in the Second Circuit, the court was very concerned with defining the forum. Is it the Twitter as a whole? Is it President Trump's personal account? Is it the common thread in the tweet? And as well, the court focused on the blocking and workarounds. The court also noted the decision from the Fourth Circuit in Davidson, and you'll see this is a very 6 degrees of separation in that the attorneys for the Knight Institute are also representing Plaintiff Davison in the Fourth Circuit, which seems like a great segue to pass the baton on to Meg to tell us a little bit about the circuit cases that are actually out there for us.
Thank you, Deborah. And as Deborah mentioned earlier, just from the beginning of this year, so in the last 5 months, we now have two circuit case decisions that impact this area of law. So that's very interesting. And in the Davison case, what was at issue was the Facebook page, the official Facebook page of Chair Phyllis J. Randall. She is the chair of the Board of Supervisors for Loudoun County, and here you can see a picture of this official Facebook page. This decision just came out in January 2019. This is the first federal court of appeals decision in this realm, specifically having to do with the intersection of the First Amendment and these social media platforms that are being used by public officials or by public entities. The plaintiff in the case, Davison, is an outspoken Loudoun County resident. He's actually also somewhat of a serial plaintiff, and we'll be looking at one of his other lawsuits that was at the district court level later on as well. His particular area of concern is the public schools and funding for the public schools. The defendant, as I mentioned earlier, is Randall, and she's the chair of the Loudoun County Board of Supervisors. The court in Davison had a very detailed and reasoned opinion, and they did spend a lot of time on the facts of the case, which, as most people are probably aware, that the devil's in the details as far as First Amendment analysis, that the factual portion can really impact the ultimate outcome. So they first noted that Chair Randall had actually 3 different Facebook pages. One was a personal profile. The second one was a campaign page. And the court said neither of those Facebook pages were at issue. And quite likely, certainly the personal one probably doesn't have First Amendment necessarily implications. That's her personal account. May be the same also for her campaign page. But what was at issue was her Facebook page that was called the Chair Randall's page, and the court refers to it as the chair's page. So that's what's at issue in this case. Also, the court noted that when she created the chair's Facebook page, she specifically identified it as a governmental official page, and that she used that page for her official duties and responsibilities. For instance, the court said that most of her comments on the chair's Facebook page had to do with inviting members of the public to public meetings, or to inform about official duties and responsibilities, such as how she was responding to the needs that arose because of the snowstorm. The court did note that some of the posts had less of a link to her official duties and responsibilities, such as a post about being proud to be an organ donor. But the court said that and found that the vast majority of the posts had to do with her official duties and responsibilities. And then the court also spent a lot of time analyzing how her Facebook page worked. Here you can see a picture of that Facebook page, and the court noted that in the left-hand column, you had a portion that dealt with links so that you could navigate the chair's Facebook page. And then it was this middle column where Randall would post do her post, and that's where the public could make comments. So it was this interactive portion of the Facebook page that the court said was at issue. And then the right-hand column was a place that had official contact information and then also had information about other Facebook pages that were following or liked the chair's Facebook page. So neither the left-hand column nor the right-hand column, the court said, was at issue. It was this middle portion of the Facebook page. To give just a kind of factual, whoops, oh my goodness. Sorry about that, I skipped all the way to the end. So let me get back to where we are. You can see a quick overview. To give a factual overview of what is going on in the Davison case, or what was the backdrop there. Davison had attended a town hall meeting that was hosted by the school board and that Randall attended in her official capacity as the chair. At that meeting, Davison submitted a question in writing that had to do about how funds were being used and implied that they were being used unethically by school board members. Randall actually answered that question at the meeting, but noted that she didn't appreciate the question and she thought it was a setup question. Later that evening, she posted about the meeting on the chair's Facebook page, and in response to that, Davison made a comment, and the comment was much like the question that he'd asked at the town hall meeting, and implied or stated that certain school board members were using funds unethically. Randall testified that she didn't know if his comment was true or not, but she did know it was not a comment that she wanted on the chair's Facebook page, so she deleted it. She also deleted her original post, which meant that all comments to that original post were deleted. She also that evening blocked Randall from the Facebook page, but then the next morning she reconsidered that decision and unblocked him. So he was blocked for maybe about 12 hours. The court, the Fourth Circuit Court, unanimously found that Randall's actions in deleting the critical comments by Davison were unconstitutional and violated the First Amendment. The first portion of the court's analysis had to do with the under color state law requirement that is a mandatory requirement for any Section 1983 claim. And the court found that indeed Randall had acted under color state law. She was using the chair's Facebook page to conduct actual or apparent duties of her office, and the court noted she was using the Facebook page as a tool of government. It's also interesting to look at some of the other findings of the court, and that is that the interactive component of the Facebook page constituted a public forum. And then the court went on to find that it was viewpoint discrimination to delete the critical comments.
Can I jump right in?
Yes, of course.
I thought it was really interesting in Davidson where, you know, she was really kind of outraged, wasn't she, that she felt like, oh, this comment was off topic and it was just, you know, it was just not appropriate to be impugning the integrity of one of the electeds that was volunteering, you know, to help for public service. And she, you know, kind of in a fit, you know, blocked him when she went to bed and then got up the next morning and in just 12 hours he was blocked. So what's the issue? It was just overnight. Nobody, no harm, no foul, right?
Well, I think the bigger issue probably for Davison was that she also deleted his comments. So while he was unblocked, the comment that he had put up there was deleted, and the court spent most of the analysis on the deletion rather than the blocking in this case. But we'll see in some of the other cases the court speaks more specifically to the blocking as well. And the Randall also made some other additional arguments which the court rejected, but they are interesting arguments. She first argued that Facebook is privately owned and therefore forum analysis just simply does not apply at all. And the Fourth Circuit said that doesn't end the analysis. Just because property is privately owned, that's not the end of the questions that need to be asked. It's also then whether the government or government official has control over that privately owned property such that it would make it subject to forum analysis. And here the court found that indeed Randall did. She controlled her Facebook page, what was posted and what was deleted. Randall also argued that the entire Facebook page was government speech, not subject to First Amendment analysis. The court also rejected that argument, saying that while the left-hand column and the right-hand column might be government speech, that middle interactive portion was not pure government speech and was subject to forum analysis.
And what did the Fifth Circuit do when it got this case?
When the Fifth Circuit looked at the forum analysis issues, we're going to go to that. I have one more slide that I want to do on this case before I hop to the Fifth Circuit decision. I just wanted to, because I think it's quite interesting to look at what questions remain after the Davison case. And one of the open questions is, what type of public forum is this official Facebook page? The court didn't answer that, didn't say whether the forum was a traditional public forum, a designated public forum, or a limited public forum. And the reason the court didn't answer that question is because it didn't need to. It found that viewpoint discrimination was at issue, and viewpoint discrimination is not allowed in any of those types of public forum. So that remains kind of an open question there. Also, the concurring opinion in the Davison case is quite interesting because it highlights some areas that remain open questions that I think will come up in cases as we're moving forward. One of those is, with the concurring opinion noted, which public officials have the ability to open a public forum on social media. Certainly not all government employees will be deemed to have opened a public forum, and this is somewhat the flip side of the question of who can be held liable under Section 1983. Another issue that the concurring opinion noted is that there is potential tension between the policies of a privately owned social media platform, such as Facebook, that bans hate speech, and a government actor using that social media platform to open a public forum. So now we move to the Robinson case out of the Fifth Circuit, which is a very recent decision just in the last couple of weeks, and this is the decision that Deborah was asking me about just a couple of minutes ago. The backdrop to this case is that the plaintiff sued the Hunt County Sheriff's Office for both blocking and removing her critical comments from the Hunt County Sheriff's official Facebook page. And it's interesting to note that the Facebook page actually states on the Facebook page itself, welcome to the official Hunt County Sheriff's Office Facebook page. We welcome your input and positive comments. And then it goes on to say the purpose of the site is to present matters of public interest within Hunt County. We encourage you to submit comments, but please note that this is not a public forum. So interesting to see whether...
I think that's called having your cake and eating it too.
Right, whether those statements will suffice to actually create or not create the type of forum that the Sheriff's Office is looking for here. The court didn't actually rule on that specific issue because the procedural posture of this case is that it was still in the motion to dismiss stage. This is also interesting because while in the Knight versus Trump case, and then also in the Davison case, you kind of have pure political commentary. While critical, it was not necessarily offensive. Here, the statements at issue could be deemed, and probably are deemed by a lot of people, to be offensive. So it gets interesting when the courts start dealing with slightly different facts. In particular, one of Robinson's comments had described a law enforcement officer that was killed in the line of duty as a terrorist pig with a shiny badge. That, along with some of her other comments, was deleted. The district court actually, the district court denied her request for a preliminary injunction and then went on to grant the Sheriff's Office motion to dismiss. The court said that the allegations of the complaint did not show viewpoint discrimination, Rather, the court said that that the deletion of these comments could just have well been done because they were deemed to be insensitive. And the court said that there was evidence that the Facebook page allowed other critical comments to remain. And the court also reasoned that Facebook's policies itself would probably require the deletion of these particular comments, and therefore together these showed that there was not viewpoint discrimination. Now, it seems like the court stepped outside of the motion to dismiss parameters that it was supposed to stay within, and indeed, when it went up to the Fifth Circuit reversed the district court on that motion to dismiss finding, saying that the allegations of the complaint were sufficient to state a viewpoint discrimination case. Now, because it's still in the motion to dismiss stage, this will be a really interesting case to follow to see how, as the facts develop and then on summary judgment or at trial, what the findings might be there.
Well, I want to jump in right here because I got a lot of questions when I talked about this a few months ago about, well, isn't it okay to just let Facebook do the deletions? That causes me pause. I think I've gone on record saying I don't think that you can let and defer to Facebook if you have adopted this sufficiently to be in and welcoming public comments. That causes me some concern about how that's going to come out. I also find this discussion of insensitive comments, I don't think to have it, if it is a public forum, that's not going to be a reasonable time, place, and manner distinction to me. What's insensitive to you might be effective speech to me. And plus, these digital forums are always very provocative. That's the whole point. And so I find that case to be one that we should definitely watch, but I'm not thinking that it's going to be very helpful for those who want to try to find a way to keep a positive community image.
Well, right, and I think that, say, even if this forum was found to be a limited public forum, I think that limiting it to positive comments would be deemed viewpoint-based, and that's not allowed in a limited public forum. Probably the only way that that the sheriff's office could make these kinds of distinctions and limitations is if somehow the lower court and then the Fifth Circuit upheld it, that it was found to not be a forum at all, or found to be a forum that was not subject to First Amendment scrutiny. And that doesn't seem to be how the courts are finding or looking at these social media platforms, although as we move forward, we'll see that there is at least one district court that has found that these types of Facebook pages are not a forum subject to First Amendment scrutiny. This slide just shows kind of some of the differing results that the district courts are reaching. Right now, the only circuit court guidance we have is from the Fourth Circuit and the Fifth Circuit, and then soon from the Second Circuit when the Knight v. Trump case is decided. Here we have our serial plaintiff again, Davison, and in this case before the district court, that was a couple years ago, he actually lost. That's a case where the court actually found that a limited public forum was created on the Loudoun County Commonwealth Attorney's Facebook page, and that they had deleted a off-topic comment by Davison that was kind of clearly off-topic, and therefore it was didn't violate the First Amendment. You had a limited public forum, and you had a policy that was being even-handedly enforced. They also touched upon the fact that Attorney Plowman was entitled to qualified immunity for blocking the plaintiff because in addition to deleting his comments that were off-topic, he had been blocked for a couple of months from the official Facebook page. And the court said, and we'll, if we have time, look at this on another slide as well, that qualified immunity applied because it was there was no clearly established right to access the official Facebook page because this area of law is still in flux. And then this is the case that I mentioned just a minute ago, the Morgan versus Bevin case, where the district court out of Kentucky found very differently than the Fourth Circuit in Davison. In this case, the Governor Bevin had deleted and blocked individuals from his Facebook and Twitter accounts that were making negative comments. And he argued that it was a personal Facebook and Twitter account. There was ample evidence that he was posting about his official duties and responsibilities, and he didn't have any other Facebook and Twitter accounts, so he didn't have a separate private one and an official one. Here, though, the district court found in Governor Bevin's favor, saying that forum analysis did not apply to these platforms at all because they were privately owned channels of communication, and he was engaged in personal speech. The court actually went on to say that Bevin wasn't suppressing speech, but he was merely culling his Facebook and Twitter accounts to present the public image he desired. So this decision is at odds with how other courts are finding at this point, but at least one court has bought into this argument. Now we turn to a case just out of the Southern District of California, down near San Diego, and in this case, the Mayor Morrison was successful in defending against this case based on both mootness and the qualified immunity defense. He had deleted critical comments from his Facebook page, and he had blocked the plaintiff, but then he unblocked the plaintiff. So the court found that the request for declaratory and injunctive relief was now moot. The court also found that any claims for damages was barred by the qualified immunity defense. So that's something definitely that people will want to keep in mind, and saying that because this area of law is in flux, that qualified immunity applies.
So a quick addition on that for a little background. Some of you may have had experience with Cory Brigs, who files a lot of the actions against public entities. And down in San Diego, what happened here was the local print media did a widespread Public Records Act request to each jurisdiction for all of the individual elected Facebook pages and any individuals that had been blocked. And then from there, Cory Brigs filed a series of cases down in the Southern District, all about blocking and setting up plaintiffs. He also filed a case in Poway in Unified School District on these same issues. So clearly it is one that is garnering some activity in the realm.
And as Deborah mentioned earlier, we don't have any Ninth Circuit guidance yet on how these cases will be determined here in the Ninth Circuit, but there's certainly a plethora of cases that are being filed. One was just filed up in Sacramento. The ACLU filed suit on behalf of 2 Black Lives Matter leaders. And there's also a case out of Stockton on similar issues. So probably before long, one of these will hit the Ninth Circuit, and we'll get some guidance from our circuit.
So Meg, we're running short on time, so you want to take us quickly through the practice pointers?
Yep.
And then let's take up at least one question.
Okay, that sounds good. So as far as practice pointers and trying to pull together everything Deborah and I have talked about, one important step is to identify the social media platform that's at issue, and recognizing that personal accounts, while they may remain personal, might be changed to a public forum. And that if you want to try to establish a limited public forum, you definitely want to state the purpose of the platform and what those limits are. It's also important to establish the rules for public participation, and again, that's specifically if you want to set out a limited type public forum. It's good to set out that you could be blocked or your comments could be deleted for violating whatever those limitations and rules are. It's good to consider setting out a retention period for comments, And then also it can be advisable to set out a procedure so that those who have comments that are deleted and they think that the comments should not have been deleted, that they can contest that or appeal that. It's also advisable to establish who it is that can post on behalf of the public entity on official sites, and to ensure that those employees have familiarity with the public entity, know who to contact to get the information, and have adequate training as well, and also have time to devote to the managing of these social media platforms, because especially if you have a limited public forum where you're going to be even-handedly enforcing those limitations, you need to allow that person time to go through, look at the comments, and see which ones may require deletion. And then for officials that are using accounts for public business, it's advisable to consider establishing requirements that they follow the agency's policy if they're using those personal accounts for public business, establish who might be held liable under Section 1983, or who, as the court in the Davison concurrence pointed out, could be seen as opening a public forum. And then some factors, other additional factors to consider are whether you can impose disciplinary action where that public official is not following the agency's policy when they're using their personal accounts for public business. And then that also raises whether the public agency can provide a defense to complaints against individuals who are sued and claim that it's their personal social media account and not any type of official account. And then here on our final slide, we just have a link that people may want to access as a social media policy that was adopted by the governor of Maryland in settlement with litigation with the ACLU, so it had buy-in from the ACLU. Deborah and I certainly haven't vetted it. It's more just offered as one resource that people may want to look at. In addition, people may, that are members of IMLA, may want to look at IMLA's, I know, drafting up a model social media policy, and also calling out considerations for smaller jurisdictions and larger jurisdictions, as considerations and resources may be different. Again, that's just one potential resource, not one that Deborah and I have analyzed in depth at this point, but maybe a place to start for individuals that are looking to review or amend social media policies.
So a couple questions came in, Meg. One was about Nextdoor and issues relating to posting on Nextdoor. And several of them are whether or not there might be a violation of First Amendment rights, and what we think about requiring council members to not, or restricting council members from posting on social media of Nextdoor. So it's really interesting here. I think that a question is posed, wasn't it easier just to totally ban anybody from posting? Yes, that would be totally easier.
Yes.
Whether or not that might be a violation of the individual councils and the elected's First Amendment right, probably. Again, controlling electeds, those who are city attorneys and county councils probably know the secret code to that much better than you and I do. I think as well it would be an interesting question whether or not if you post on Nextdoor you might open the public forum to, if you're trying to get public input at that venue. It's certainly different, but it might be the next Facebook page for those issues. There's some questions about the Brown Act. I think others have weighed in at the league that they think if you have more than, if you have 3 or more electeds, that you might have a Brown Act issue. I'll leave that to the league conference next week to answer that. I think for litigation, any of those comments will be fair game. And finally, we got a question that I'd like us to tease through a little. Can a personal Facebook page of a public official be converted to the city by including city events? So I'm going to assume in this analogy that the only thing that's on there is just saying you're invited to come to City Hall because we're having a discussion of the budget, or we're having an open forum. Do you think that that would make the personal Facebook page then convert into a designated public forum?
Well, I'm going to give a very lawyerly response. It depends. I think it would depend on probably who the public official is. Again, whether they are that type of public official that can be seen to open a type of public forum or be held liable under Section 1983. I think it might also depend whether that public official had multiple Facebook pages, in an official Facebook page and then one that really was more personal, and kind of how much public business or public posting was happening on that Facebook page. I think those would be some of the critical questions.
Well, thank you for helping us tease through these questions. I think there are going to be a lot of questions that are come forward, and we appreciate everyone's time. If we didn't get to your question, reach out to us, and we'd be happy to tease through with you either via email or give us a call.
Great. Thank you, Deborah and Meg. For our audience members, I'm going to go ahead and leave their contact information up there for a little while, so you can grab their email address if needed. And by the end of the week or early next week, we will circulate the PowerPoint slide deck and CLE certificates for those who requested. Thank you, everyone. Have a great day.